Law is a system of rules and regulations, created and enforced by social or governmental institutions, designed to regulate behavior and maintain order within a society, with its precise definition a matter of ongoing debate. Law consists of many fields such as property law, constitutional law, international law, and criminal law. One major division between fields of law is the division between public and private law. Beyond this, the law is also categorized into substantive and procedural law. In this video, we will learn about basic concepts of law including private and public law, substantive and procedural laws, legal subjects, juridical acts, duties and rights. Private law deals with the mutual relations between citizens. Both property law and contract law are major branches of private law, which regulates things such as sales, ownership, and mortgages. A third branch of private law is tort law, which deals with the compensation for damage that occurs when there is no contract. Again, other branches of private law are family law and the law of commerce, which regulates, for instance, the transport of goods. A special branch is private international law, which determines which laws are applicable if a case is connected to the law of more than one jurisdiction. For instance, it determines which family law governs the divorce of persons with different nationalities. Public law is defined as the branch of law concerned with the organization and operation of the state and its institutions. There are four main branches of public law. The best-known branch is often criminal law. Constitutional law is a second important branch of public law that organizes the state and the government. Constitutional law and deals with the division of government powers, the functioning of democracy, the creation of legislation, and the relationship between central and local government agents. Traditionally, it also deals with human rights, but that field also falls under public international law. Administrative law is the third branch of public law which deals with many interactions between government agents and civilians, or private organizations. Administrative law has many branches of its own, including social security law, environmental law, and tax law. International law, the law that regulates relations between states and international organizations, is also a branch of public law and is therefore sometimes also called international public law. Beyond the division between public and private law, the law is also categorized into substantive and procedural law, forming a separate and equally important distinction. Substantive law consists of rules that determine what people should do and that give people rights. Not everyone always complies with all duty-imposing rules, nor are all the rights of persons always respected. Therefore, if law is to function well, it has to provide means through which compliance with duties and respect for rights can be enforced. These means are given by procedural law. This field of law provides the rules for court procedures and for the organization of the judiciary. Legal rules impose duties upon and assign competencies and rights to legal subjects. These legal subjects are typically human beings, but in theory the law can give the status of a legal subject to anyone or anything it wants. For example, a foundation, a company with limited liability, a state, and a municipality, all of these can and in many countries do count as legal subjects. Human beings are called natural persons, while organizations that have received the status of legal subjects are called legal persons. The consequences of being a legal subject vary from one field of law to another. In criminal law, being a legal subject means that one is addressed by rules of criminal law, and can become punishable in case of violation. Natural persons are legal subjects in this sense, but it is not evident that legal persons are also addressed by criminal law rules. In private law, important consequences of being a legal subject are that one can have rights, such as property, or a claim to be paid money, and that one can perform juridical acts. These consequences pertain to both natural and legal persons. The law is dynamic, both in the sense that the rules change in the course of time, and in the sense that the legal positions of individual persons are subject to modifications. These changes in the law are mostly the result of the application of a dynamic rule. They are legal effects. However, not all of them just happen. Some of them were brought about intentionally. Private persons should, for example, not be able to appropriate what belongs to other persons, nor should they be able to marry two other persons who do not want to be married. A municipal legislator should not be able to create rules that apply to everyone in the world. However, within certain limits, legal subjects should have the power to change legal positions, or even legal rules. This power is given to them through the possibility to perform juridical acts. The phenomenon of juridical acts exists in most, if not all, legal systems of the world. Two of the most important notions in the law are those of duty and right. It is sometimes thought that the two are closely related in the sense that the duty of one person corresponds to the right of another and the other way round. The notion of a duty is closely related to that of a prohibition and that of permission. Duties are meant to guide persons in their behavior. This means that duties are always addressed to one or more agents. Sometimes a duty addresses everyone. This is, for instance, the case with the duty not to torture. The action that a duty prescribes can both be doing something and abstaining from doing something. An example of a duty to do something is the duty to pay one's income tax. An example of a duty to abstain from something is the duty not to commit theft. There are different kinds of rights, which differ considerably from each other. If one seeks a common denominator for the different kinds of rights, there are two characteristics that most rights share. 1. Rights are interests that are protected by law. And 2. Rights can be disposed of by the right holder. The different kinds of rights can, with some goodwill, be grouped under three headings, that is, rights regarding a person, rights regarding an object, and liberty rights. The rights that most closely correspond to an obligation are the rights regarding a person, or more briefly, claims. Legal obligations are the result of events to which the law, most often private law, attaches an obligation as its legal effect. Typical examples of such events are contracts, and the unlawful events that are grouped together under the denominator torts. A tort is an illegal act, such as one that causes a traffic accident. If the tort caused damage, the tortfeasor will have to compensate for it. The claim is more than merely the flip side of the obligation. Most claims can be transferred to someone else, and the holder of a claim usually can waive his right, thereby bringing an end to the corresponding obligation. Where claims correspond to obligations and are therefore rights that someone does something, rights regarding objects are essentially relations between the right holder and the object of the right. The most familiar example of such a right regarding an object is the right of ownership, which the owner has with regard to the owned object. Other examples of rights regarding objects are copyright and mortgage. Rights regarding objects are usually called property rights. A right regarding an object normally goes together with a general prohibition for everyone except the right holder to use, damage, or destroy the object of the right. The right itself can then be seen as including an explicit permission to use, damage, or destroy this object. Liberty rights are usually a category of human rights. They involve an explicit permission to do something, such as expressing one's opinion, becoming a member of a political party, or casting a vote. The right to cast a vote is more than only a permission, it also involves a competence. The right goes further than merely the permission, however. It is a right and not an ordinary permission, because it cannot easily be withdrawn. A government that recognizes the right to vote cannot simply cancel the permission if it wants to.